IP strategy, which I think was set out here, of course, by Dominica and also very well by Ms. Partlick this morning, that it contains a lot of elements, sort of the what, when, how, why, etc., to creation and maintenance of IP, for example. But there seems to me there's a difference between IP strategy in general and IP monetization strategy. So this is something you can disagree with me on if you want. We're hoping as a group that you do. Just listen to my words and then attack if you want, especially these two because they're the speakers. But the question overall that I had was, how do you manage what must be conflicting IP monetization strategies with different businesses? Tuk talked about commercial versus trading, but versus grid versus generation. I cannot see that all of them have the same IP needs or that they want to generate, let's say, or monetize, whatever that means, based on the value, right, of the patent to the company. They must have different values for these things. So how do you resolve the conflict between, even internally? And that could maybe be for both, of course.
You want me to start? Okay. Yeah, it's a very interesting question because actually, when we file patent application, at the beginning, we don't know what's the value of the patent or what's the value of the product or technology. So it's just purely based on certain speculation. And the speculation would be in some way with time have additional input in order maybe to have a right assessment of the value. And so what we can do at the very beginning is maybe to classify or to give a certain, let's say, indication if the patent is going to be core or non-core. Okay, so we can actually try to split into the core technology and non-core, and of course to find out if those technology can be licensed to a third party. And we can also look at if the technology of the patent can be licensed to competitors or for adjacent competitors or adjacent technology. So there are different category of patent, of course. And when you have to deal with, for instance, GE Aviation or maybe for SNCMA or Safran, certain technology are core because that's the important or the essential technology that they want to keep for themselves. And sometimes those technology can be of interest to the national defense. So when you file a patent application, for instance, in France or in Germany or maybe in the US, you have to know that the Ministry of Defense have a look on those technology. And afterwards, they can authorize you to have that kind of foreign filing, or they can also preempt on those technology and request that you keep it secret. And those valuable patent or technology are important, but in some way it has been preempted by the government. So you have to keep it for a certain number of years until the technology is, let's say, less essential or less dangerous. So you have different areas, like for instance, the nuclear energy, the encryption, and as well as the biotech, and of course the certain materials, because they can also be used in order to propel. We talk about the sky rocket. So some of those materials can be very essential for a company to have access to the space rocket. So just to give you an idea that sometimes, even though the technology is core, sometimes it's not possible to license, and sometimes it is, in order to maybe open the barrier to let the competitors enter into the business. And once again, the value, as Dominique was saying, it's very difficult to give a value. And when I was working for Nokia, at that time, Nokia was selling their patent. And the question was to know how much can they sell or how much can they license. And at the time, we were about to launch a lawsuit against Google because we were just looking at how we can monetize those patents. And so we saw that Nokia was in lawsuit with Apple. And so finally, the end was that Nokia won the lawsuit against Apple and got some $100 million for using the Bluetooth technology. And so Nokia was reiterating again, against some competitors, and Google was one of the main target. But it turns out that Google finally decided to purchase the Motorola Mobility for something like $12 billion. And when you divide the number of patents that Motorola had at the time, the rationale was that a patent was worth something like 700,000 US dollar. So is it the price of each patent? You don't know, but it's actually the price that Google pay in order to be safe, in order not to be sued by any competitors.
Yeah, that was the slide which I showed how much strategic goodwill you have in the price, which is not the value, basically. Yeah.
And since Dominiki is taking the microphone, I would have to ask her how actually at Siemens you are trying to put a value on the patent, and afterwards maybe to find any licensee that would be interested in those patents.
Well, for this kind of valuation, so you have to always differ for what is also your role as a appraisal. So if the valuation is conducted for tax purposes, then you are very limited in a space of how you act as an appraisal. Whereas if there is a licensing negotiations happening with a third party, then you are more free and to be also, I don't call it non-objective, but you can play in different scenarios based on when you discuss with the licensing person, okay, how the negotiations are going, how the potential licensee behaves, and then with this respect you can play, you can set up a different scenarios, and then you can just provide him a certain values or numbers, which at the end will never play a big role, but they can help the licensing council or the licensing negotiator in which direction to go. Also on the slide there was where I put the first slide says that the valuation can serve also the negotiation purposes. But this is not the mean where you say this is how it goes. For tax purposes it's different, but for the negotiation purposes you give just like your, I don't call it personal opinion, but it's like not that objective.
And I want to follow up a second question because now I'm getting into the business units. I want them to make money, of course. How do you, or maybe I won't be that direct, but what are the possibilities for valuations, particularly at large companies like GE and others, where you have a lot of what I would call cross-disciplinary patents, or the smart patents, or the cloud patents, or whatever we want to call these things, where a number of competing business units will be using them, but don't they all need different valuations, or because they have different interests, don't they?
Yeah, definitely they have different interests. It depends always the purpose for which you are valuing. So if you are valuing, let's say, what's the internal use of the patent for any corporation, then you definitely consider both business units in the valuation model. You can't separate because this is the benefit, the financial benefit which the patent or the IP brings to the company overall. If the specific assignment would be, okay, what does this mean for this particular business unit, then you still have to extend because you take it as a company. Different would be, okay, what would be the value on the market against a third party. That's then a different consideration. But if I value it from a company perspective, then you have to include both.
Don't worry, I'm not going to hog the time. I'm going to let you ask questions now. I'm going to be quiet for a while. So, who wants to start?
I think I have a little remark about the valuation. Like in my opinion, the when you evaluate IP assets, on the contrary from the like tangible assets like real estate, like you use market value. I don't know if you use like some equipment. There's like various methods, but with IP, it's like I think the most important thing is very subjective. For example, as you just mentioned, it depends for what purpose are you evaluating. For example, for tax purposes or for M&A or for something else. And then, but just by changing some variables, I don't know, for example, like discount rate, you can get the best, worst scenarios. I mean, or the value of IP. Let's say in one instance, like $10. Then by changing some variables, you get 20, and both of the valuations are gonna look like trustworthy. So I mean, I've never been doing valuations for like patents or like more portfolios. I mean, I've done few trademark valuations, and that's what I noticed. I mean, like when you evaluate a small business and trying to put a value on a trademark value for that business, it's usually you evaluate the income that is this business is going to bring in the future, and then that's how it works. So I don't know if it goes the same with the larger portfolios, like in Siemens. Probably you do. I mean, it's interesting really how you do how you go about that.
So you are completely right. Like if you value tangibles or intangibles, I put this into the backup slide. It says the methodologies as such and approaches are always the same. So you can't invent the world new. The only difference is what kind of approach do you use for valuing intellectual properties. So usually it's in order income cost and market approach, whereas market approach for patents not typical. The only kind of hyper model is for relief from royalty, where you are extracting royalty rates from external licensing deals happening outside of your company if you don't have any comparable transactions within your company. But you are completely right. That's nothing different to any other valuations which you do. And yes, it also depends on the assumptions which you are putting to the valuation model. So if you use different VEC rates or discount rates or royalty rates, then definitely you have 3 different results. But you always have to consider what are you valuing. So if I'm valuing a patents, then you have to see, okay, what is the what are the functions, which are the legal and the economic and technical aspects of the single patent. And then these are the assumptions which you are putting into the valuation model plus on the top to the average like royalty rate or discount rate, yes. With the trademark is a little different because then you can see the price premiums which you can charge, and based on the price premiums you can say, okay, this price premium is generated just because we are using Coca-Cola trademark or something. So yeah.
What I may add is that very often, you have to differentiate between what we call the consumer electronics from the less consumer electronics, from this way, because there are certain technology that are very competitive, where you have a lot of players, and those players are willing to pay a high price to get into the market. So that's why you have a lot of Japanese company in the electronics, like Hitachi, or also maybe Samsung from Korea, of course. And when they want to enter into the market, they are willing to pay a high price, to get into the semiconductors, for instance, or to get into telecommunication and so on. And once they once they gain the market, afterwards maybe they are less willing to pay the high price. So it's just depending on the opportunity that is being offered and the time. And of course now we are going into maybe different technology that are not as important as the semiconductors 10 or 20 years ago, and the telecom standards patent like it was maybe 5 or 7 years ago, when you have Apple and Google that are trying to get into the mobile industry, and then you have a lot of competitors that are willing to pay the high price to get into that business. Yeah.
Yeah, I'm just curious what role the potential for litigation and the evidence of the valuation and the transactions you entered into, how does that impact the evaluation? Because you'll have somebody potentially you sue for infringement, and you have to establish a reasonable royalty potentially if you don't get an injunction. And I'm just curious, what in the all this internal valuation you do in negotiation, what role does the potential for litigation and the setting of reasonable royalty play in your analysis?
Well, this is a good question, and I was also thinking about this kind of cases, what kind of role the valuations can have, especially in the U.S. as potential risk in the U.S. litigation cases. Honestly, if the patents are not litigated or there is no sign of potential litigation happening in the future, then I don't consider it this kind of factor. If there is a risk or a potential litigation happening, then you definitely don't do any reports or disclose any valuation results or assumptions on that valuation topic. So it's basically some kind of like non-disclosure act, but there is also no valuation like assignment as such happening for this kind of reasons then.
If I may add something also, maybe you can refer to the NPI, the non-practicing entity, and so those non-practicing entity, they are trying to make the best of their patent or the best of their IP, and they can actually file lawsuit against big players to make sure that they can get maybe some 100,000 of US dollar or maybe some million, just because of the litigation cost that is quite huge in the US. So sometimes these big company, they are willing, to let's say have a transaction and saying that, okay, instead of having maybe those kind of lengthy discussion and those litigation costs, so we are willing to pay a certain amount of money. But that's not, once again, GE GE point of view, but it's just that in the telecom, it happens very often that those non-practicing entity are using their patent, and you can Google and find out who those entity are, and at the same time they try to use only the US market, simply because the patent system in the US is, let's say, conducive to this kind of behavior. But in Europe, it's harder. Yeah.
I had a case where one of my clients asked, can you please tell me how much my patent is worth? So we put some people on it, and it was about smart electricity meters. So the stuff that you put in the homes, and then you can communicate with that remotely. And we had some people evaluate that and say, okay, if you have to replace every meter in the region where the patent is in force, and then calculate maybe a value of the royalty fee that you would collect, because you're not going to do that yourself. And they came up with a value of 40 million euros. Few months later, we got an office action in the US, and we had some novelty destroying prior art. So, to my opinion, that value was immediately gone. Do you consider prior art or do some research when you are putting a value on patents?
So if you do a single patent valuation, then definitely it's more difficult when you are valuing portfolio consisting of hundreds of patents. Then you rely on, at least we in Siemens have internal kind of qualitative evaluation tool and rounds, out of which you can see, okay, based on the number which the patent or the patent family has, you can see, okay, this might be some problem, and then you can get some discount of the value. But what is then, the question is, what is the real discount? It's everything negotiable. So you don't find any literature or sources on this kind of fact. So it's then your experience, and I sometimes call it a gut feeling, because we don't have glass balls, unfortunately, yet for predicting future. So it's everything like how you put it on the paper. So you can justify 10%, you can justify 50%, but if there is an obvious office action for prior art, then definitely there would be a diminish in value on a certain level. Yes. But that's why what I say, IP valuation is a cross-functional topic. So I started doing this valuations 2010, and usually only accounting people were involved. Currently, I'm saying it's a cross-functional topic. So you have to bring IP people, R&D people, business people, accounting people into one table, and you have to discuss. Because it's not only if the patent professionals or patent attorneys do the valuation, they see the world only as they want to see the world. The same accounting people see the world. And you have to, as a valuator, bring these two worlds together to understand in order to derive a concrete value. So that's my takeaway lesson, where I see, if you do, or if you are faced with valuation, set up a cross-functional teams. That's the best.
Yeah, I think what Dominiki was saying is perfectly right. And we have to have a cross-functional discussion from the tax point of view, from the engineering point of view, or from the accounting, and of course from the management point of view too, because sometimes it's very strategic decision to license or not to give a license. And just to come back to what you said, the discovering of the prior art can be, let's say, destroying the value of the patent. So each time, actually, when a consumer electronics manufacturer is having a licensing negotiation, very often the licensee or the potential target licensee will always find a weak spot of the patent, either in Europe or US, or maybe also in Japan or China, to see if they can test the validity of the patent. So they can file either an opposition in France or in Europe, or a kind of IPR, that is the inter partes review in the US, and also some other means in Japan or in China. So just to make sure that the negotiation can last long enough, so that they are not going to be struggling to pay certain amount of money. And at the same time, if you look at the way that those companies are using their patent, is that they always use to strike at the crucial moment. Like, for instance, if you have a fair, in Hamburg, or maybe in Las Vegas in the US, you have to see if there's any potential IP risk, that you are being hit by a claim in terms of IP litigation. And sometimes that is the crucial moment. And you can certainly heard about the Samsung case and so on. So that's also a risk that, sometimes the IP manager or the IP strategy people hold their breath during those kind of fair.
Another question? Come on, somebody's got something. I know you're holding back.
If not, I have a question actually for Sean, right? About the Visa card, because I mean I've been practicing IP for several years, and I happen to work for Gen Plus, that is one of the semiconductors, or let's say the chip or the smart card player, and they were trying to get into the U.S. business, and especially to get Mastercard or the Visa card as a client, because at that time the American credit card or debit card, they only use those kind of magnetic stripe instead of the smart card. Since you are within the smart card industry, you know why did US switch from the electromagnetic stripe to the chip? Yes.
Essentially, Visa and Mastercard mandated it because it provides far stronger protection against fraud, and that's the essential reason.
Yeah, I mean, because actually the chip, at that time it was invented by a few folks. I'm sorry, like Moreno, and he's a French guy, and it was back in the maybe 1980, and so he was trying to monetize his patent. And so he finally ended up, monetizing that patent with Schlumberger and with some other European company, because the European they used they used the smart card very early, and it was only maybe recently in the US that they start using those kind of chip, and so maybe the Moreno patent has already expired. So you have to look at the fact that sometimes certain industry will wait until the expiration of the patent to get into that kind of technology.
I'll take the fifth on this one.
Well, then I'll ask you one more question, just a general question again, more structure-oriented, and I say that's German because we have to think of structure, But isn't part of this valuation and this business strategy and IP monetization strategy somehow still linked to who pays at what period for this IP? Because I know the circumstances where business units have to pay out of their own pocket for up to a certain time in some companies, then it becomes a corporate property. I think that would change the whole attitude on how you would approach it, or vice versa. Does the corporation itself pay for everything from the beginning, of course, or does the unit that's actually making money or marketing or using take over those costs? So do you have any experience or can share something about that?
I can just say something from a tax perspective. As I said, OECD BEPS action plan, which says now the legal ownership for this kind of purposes is not as important as the economic ownership, where you have DEMPE analysis, where you definitely have to prove that you are developing, enhancing, protecting, and doing everything for the IP. So if you are the one who develops, enhance, and protect and maintain, then you are the owner. Well, in cooperation, it's like it always depends.
Maybe I can add a few things, but that's only based on the, let's say, economic standpoint. I think that IP is a creation of, let's say, Western, economy. And some people actually who are, let's say, on the left wing or on the left side, they tend to look at IP as a new way of colonizing weak economy, because it's the way to drain all the value, all the benefit from, let's say, less developed country in order to get all the best of them. So that is something that can be looking at and discuss if you think it's possible. But anyway, you have to know that in the let's say the WTO, that is the World Trade Organization, IP is a crucial. It's crucial because if those new economy or new country want to join the WTO, they have to abide by the TRIPS agreement. and now it has become part of the economy. And I'm originally from Cambodia, and I'm happy that there is a lady here from Cambodia who traveled from Phnom Penh to Brussels to attend this conference. And so Cambodia signed without reserve the WTO because they wanted to get into that economy or into this streamline. And sometimes, it's just going ahead without knowing exactly what is waiting for those small economy, but that's the way it is. And I guess that IP is quite important for anyone, not just small economy and big economy. Everyone create, anyone can innovate.